thank you everyone for joining us today to B2B, business to business, advertising and sales, how consumer protection laws apply when the consumer is the business. I'm Shaheen Rothermel. I'm joined by my partner, Ellen Burge. We're partners in the advertising group here at Venable. And we're really excited to talk about this today because we've done a lot of webinars about consumer protection laws when you're thinking about the normal consumer, somebody who purchases something for personal or household use. And today we're really going to focus on companies when they're selling to businesses, the way we think about businesses, as well as small businesses, because we're seeing the enforcement and legal landscape in that area change a lot. We've got a lot of content today. Please feel free to submit your questions through the questions feature. We'll do our best to get to them now. Otherwise, we'll get to them after the webinar, and you can always reach out to us with our contact information here. And with that, Ellen, would you like to start?
Sure. Okay, so our first topic is going to be really trying to figure out who is the business consumer. It sounds like an oxymoron, but when we took inventory of how many questions we get in this space on how do I sell things, how do I market my products and services, we hear them from software sales companies, fulfillment houses, call centers for customer service or telemarketing call centers, e-commerce platform providers, payment intermediaries, payment processors, banks, lead generators, companies that might sell programs and services to help ease licensing requirements in the states that businesses have to do. There's any number of different things, and what we go back to are the consumer protection roots that we have in the sales and marketing space. So there is a lot of enforcement in this area. None of the regulators at the federal or state level are shy to really make their mark here and to protect what they will say is the small business, but I do feel like it has expanded over time. We're gonna get into some discussion later about like what is truly like, you're at an arm's length contract with your big business partner and you're negotiating and you are handling things that way versus sort of more of a mass market product or service. But anything that is sort of promoted to the business community as a product or service that they can sign up for or purchase that they can use is really going to be covered by this stuff. So anyway, there's no size requirements in the laws. As the slide says here, it's typically thought of for protecting small businesses and sole proprietors, but there are cases like the FleetCor case, which is up here, that is just one example of sort of how a business need not be that small. In the FleetCor case that the FTC initiated many years ago now, and it has sort of been through a very winding litigation route. This was about fuel cards that were sold to fleet management services, and so those are not your typical small business. I mean, they're not super large, perhaps in some cases, but here the underlying conduct that the FTC brought up were fuel cards that the drivers could take and fill up in fuel stations, and they were marketed as, hey, when you pay with their card, you'll save 5 cents a gallon or whatever it may be. And the issue there that the FTC thought existed was that the savings weren't really materialized. In some cases, for example, when a driver showed up and paid with the card, there was a convenience fee added on to the sale transaction. So when you subtract out the convenience fee, are you really getting the savings? So it's these kinds of issues that are coming up and that we're looking at. So let's move on. So just some baseline standards. We will get, we talk about this in terms of UDAP. So unfair and deceptive acts or practices. Every so often there's an extra A in there for abusive, and we'll talk about what that means. But in the Federal Trade Commission world, which is, sort of very prominent in the B2B type of space and in the states, they look at UDAP. So the standards are very basic. None of this stuff is ever black and white, and many of you work with us and know that this can be a challenge. It's all a little bit subjective, but looking at sort of I don't know if you would call this black letter law, but whatever they define it, an unfair act is listed here. This is really something that is going to cause injury to consumers in some way that they could not reasonably avoid it. So unfairness is very prominent. When consumers are charged for something, a hidden fee put in there, that is something they could not avoid. They couldn't opt out of it. So we see a lot of that there. And when I say consumer in this, I'm so used to
Yeah.
saying consumer,
Yeah.
but you know what I mean.
When we use when we use the word consumers, we'll be talking typically about businesses. So for the purposes of this, the
Yes.
blanket, consumer means business. And the reason why we use the word consumer is because in the statute, they are worded as consumers. And we always tell the regulators or plaintiffs' attorneys or judges when we're dealing with these cases, consumer means consumer, and consumer is defined in a lot of these statutes. But unfortunately, they've now just read words into the statutes, as regulators are wont to do, to say consumer now means business. If you're selling something to anybody, that's a consumer of the good. It's a customer that consumes a good or service. So
that's right. And sometimes even, deceptive, you can see, deceptive is pretty, it's misleading, it's deceptive. So think about those standards there. But sometimes in a state consumer protection law, there will be very specific language saying that this is for, this relates to the sale of goods or services for household, consumer, personal use, things like that. But general UDAP, not often. In fact, let's move on to the next slide. So here's just we teed up a couple of examples. So here's the I don't know why we picked Tennessee, but we did. So there's a Tennessee law. You could see the way that they define it. We call these sort of mini ITC acts, but their broad UDAP law there is, you can't engage in an unfair, deceptive act or practice that affects trade or commerce. And trade or commerce is defined very broadly to not be narrowly honed in on consumer, household, personal use goods or services, but very broadly. And then we don't always get this in UDAP type laws by our state, but Kentucky does list out some practices and examples of things that is a UDAP violation. And so we've listed them here for you whenever you get these slides. You can look at them, but sometimes they're helpful to know. If you're not going to get it straight from the law or the statute, you'll find it in the cases. But it is important to see these here, right here in the law. Okay, then here's the New York law. This is an interesting one because New York, we're gonna their UDAP law. It's actually not UDAP. It's just DAP, I guess. There's no unfairness yet. So New York law right now only prohibits deceptive acts or practices. And a lot of things can be put into the deceptive bucket, and a lot of things that are unfair could also probably find a way into this deceptive bucket. And New York, like some other state laws, has a private right of action to enforce its laws. So there's a lot of activity in New York, including on the B2B space. But there's a proposal floating around. It was actually passed by the legislature in New York. I don't think it's been signed yet, but it is this concept of the FAIR Act. It's an acronym, but the FAIR Act was really something that the New York Attorney General was very supportive of and helped push through to add abusive and unfair practices into New York's consumer protection law. A lot of this actually was done at the change of the administration because there was some concern that the states would have to pick up where the federal government left off on consumer protection or B2B protection or whatever you want to call it. So we do have the FAIR Act in New York. With the FAIR Act would have causes of action to go after unfair or abusive practices. And this is a trend we're seeing more frequently to sort of strengthen these things. So
that's right. And one of the things to note here is that we're talking generally about unfair and deceptive acts and practices in these various state laws, where you're seeing specific statutory language that's changing to say that this now applies to activities of sales and marketing to businesses or small businesses. Mm-hmm. And that's the general umbrella rule saying thou shalt not deceive people. But there are also some specific laws that we'll be talking about here in a little bit, where those statutes, such as ones applying to automatic renewal or telemarketing activities, do have specific language relating to business-facing companies that sell to businesses or small businesses. And we'll see that in the language. So just because a state's UDAP law uses the word consumer, defines consumer personal household uses, doesn't mean there aren't other provisions that apply to your business in other sections of the law or other marketing and sales activities you're doing. So it's not a situation where you see the law, it uses the word consumers, you're good, forget about that state, move on to the next. Sorry for interjecting there.
No, absolutely. That's right. This slide is really nothing, other than to show you how proud New York is of their, consumer protection in the B2B space. They've been doing it for years. They're really big on, financial products and services like merchant cash advances, equipment leasing arrangements, small business loans, things like that, so.
New York's been active in all of it, I would say, California as well, but other states are stepping into the fray, as you said. And here are some examples of law enforcement in the business-to-business sales and marketing context. There have been cases and ongoing investigations that we're dealing with where you have general misrepresentations made to induce payments. So if you see, for example, a website or marketing material that could potentially lead companies to believe that the defendants are affiliated with a government agency or affiliated with the government, and that the businesses are required, their customers are required to purchase something from the defendants. In one case, it's labor law, but also in like the Fleet Corps example, or not the Fleet Corps example, but we dealt with a case where it appeared that there was a registration required and it wasn't actually required, and the government alleged that the company held itself out as being affiliated when in fact it wasn't. And there are actually laws surrounding that too in the consumer facing standpoint, but we're seeing that in the business facing standpoint as well. General deceptive sales, when you're pitching things like advertising placements, a company that sells advertising space to small businesses, misleading those companies about where those ads would be printed. And that is a general, I'd say substantiation, misrepresentation issue that we see in the consumer context, but now it's also in the business context as well. Misrepresentations about cancellation. Early termination fees are something that we are seeing. It is so hot in every context where you have a contract, it's a fixed term, and if somebody cancels before the end of that term, or if they cancel before a certain minimum commitment in an auto renewal contract, that then there's an early termination fee that's imposed. There's a lot of activity surrounding that in the auto renewal standpoint, in the general unfairness arguments, whether or not it's disclosed, whether or not it's an impermissible liquidated damages provision. So we'll talk about that a little bit. Misrepresentations about monthly fees. Is there a cap on fees that the services won't exceed a specified amount? This can be in a general form agreement, but it can also be in your one-off contracts if you're a company offering services and you have statements of work. You have a retainer. Sometimes there's an overage provision there. But if you're making statements about the monthly fees to your customers and how much that's going to cost, really being mindful that if you're going over in that is something that could be challenged. Savings claims. You can save this amount of money by coming to our service as opposed to another company's service. Unfair debiting practices. We're seeing a lot of activity in the law enforcement area about this. We'll talk about it a little bit, where the business will withdraw money from its business customer's bank account without express authorization, including after authorization was revoked. Hidden auto renewal clauses. Ellen and I are members of the Venables Auto Renewal Solutions team, or VAST, and we talk a lot about auto renewal disclosures and evergreen contracts in the consumer standpoint, but also in business-to-business service agreements. Is it clear that the service agreement or the products are going to auto renew after that year? You're going to have to continue paying for it unless you cancel. And one of the big things too in the evergreen contracts is if there's a cancellation provision, a lot of times companies want to have a certain notice provision of 30 days in advance. And if you don't cancel 30 days in advance, then you're going to auto renew for the next year. And we're starting to see challenges to that, both from law enforcement, but also from individual plaintiffs saying, I didn't cancel, but I don't want to spend the other couple $100,000 for that next year. And you didn't adequately disclose the auto renewal. So maybe it's not a specific challenge that's being brought to you by the FTC, but the question of whether or not that's even going to be enforceable, because the defense to paying that is, well, it was unfair under UDAP, and even though I am a business, UDAP protects me. Misleading leasing terms from point of sale systems, printers, telecom services. Business financing, that's a huge one, particularly after COVID. We've seen so much with the Small Business Administration with loans, where you have companies soliciting loans through lead generators that are making misrepresentations about the cost of loans or the availability of loans, or that they're affiliated with the government again. So you see that trend we're gonna see about affiliation with the government. And then telemarketing. Telemarketing is always gonna be a hot one. The FTC and state attorneys general had a huge sweep against what they considered robocalls and telemarketing activities, challenging the telemarketers themselves who were pitching services to business, as well as the companies who were providing those underlying services, as well as lead sellers who were selling credits and loan offers as well. And just general false advertising claims made to induce businesses into signing contracts. And when we're looking at the specific types of false advertising claims that are being challenged, there's general claims about the product, performance, efficacy of the service. You'll save this much money by using our service as compared to our competitor service for your business, whether it's a payroll company, whether it's advertising services, whether it's a tech company, any of those things. You're offering services and you're saying everybody wants to save money, everybody wants a better service. Claims about that really still need to be substantiated. The expected revenue and efficiencies from using the services. Artificial intelligence, we'll talk about that a lot. When you're making claims about AI and how effective the AI is going to be, what the AI is doing in terms of privacy, the authority of it to use the data, and the IP that it's using, claims about that, the Federal Trade Commission is all over that. That's huge. Then comparative and superiority statements, just generally saying I'm the best in the industry, I'm better. And again, false statements of association, not only with the government, but also with the companies that you're partnering with. So Grubhub had a class action that was brought by its restaurant customers that claimed that Grubhub falsely advertised that those restaurants were its partners, when in fact there really was no guarantee. The affiliation was only that the restaurants used the platform. So a lot of different types of advertising statements that are being challenged now. And really what I would say, I think what we would say is it's really anything you're saying to induce companies to enter an agreement or purchase your products or services has to be substantiated. Look at it, look at what you're saying, look at how you're saying, how you're selling, and that type of thing.
That's great. Okay, just a little bit more on sort of the small business financing concepts, because these are really big ones, and these are very popular, prominent types of offerings out in the marketplace, especially now with all the sort of fintech advancements. But I know this seems a little old, this FTC sort of staff report that had published back in 2020, but this was sort of right after the change in administration last time. So this was something that was started under the, it takes a long time for them to research these things. So this was an initiative that was really under the last Trump administration. And so it shows you there was some interest there on these issues, but again, financial harm to businesses is a really big topic. It's things like merchant cash advances, things where people are promising immediate funding for the promise of future receivables. There's a lot of issues in there, even though, I mean, there are debates on whether or not these types of products are loans, and they're generally thought not to be, but you know, again, things change and shift over time, and there's some state law issues going on there too. But you know, there are hidden fees or potential late fees or other problems with these types of things that, if not done well, can become sort of a UDAP action. So we point that out here. I think the next slide just has an example of one of the cases that came out around this time. This was again sort of more of a merchant cash advance type funding, and then there were also some collection practices thrown on top of this and other sorts of things. So, you know, small businesses, we often think about consumers being poorly treated when it comes time to collections and debt collection and things like that, but businesses are just as prone to those issues, and the FTC has pursued it. Okay, we can't talk about consumer protection without talking about the CFPB. The CFPB, I felt, right now everybody knows they're kind of dormant, I guess. And they did have sort of this abusive additional A in there. So, and abusive, by the way, is something like I don't know if we covered it, but whenever, you're not giving your customer the chance to even see a term, like you're just sort of completely hiding the ball. It comes up in dark patterns a lot when we talk about those types of things, but I did feel like the CFPB was creeping a little bit, scope creeping and very much going into this space, and in fact it was, it had, a small business lending rule that it had issued, which is not enforcing right now, but it has had some other cases along the way, even some of the activity it has done in the payment processing space was really, the CFPB's jurisdiction is over covered entities that are covered by their jurisdiction, and those are really supposed to be entities that are selling consumer financial services, but going after a payment processor who was selling services to businesses, there's, again, scope creep. So we don't know what will become of CFPB in this space as things evolve and change, but it's one I would just, when we do this presentation again in a few years, we'll see.
Yeah,
how
we
this
might be saying
changes.
something completely different,
That's right.
absolutely.
All right, so now I think we're gonna go into marketing practices, so a little bit more.
Yeah, so going into those laws that we previewed in the beginning, which is that just because you don't fall under the general consumer protection or mini FTC Act, you might have some obligations here that are real trip ups that you could find yourself with a lawsuit or a regulatory action. One of the biggest areas of law is telephone, text message marketing, anything that you're using outbound telecommunications to reach your customers. When we're talking about the risks of this, we're talking both if you're a company that offers telemarketing services to businesses, but also if you're a business that uses telemarketing via text message or telephones to get customers for yourself. We see text messaging a lot throughout these industries. And the FTC, the Federal Trade Commission, and the Federal Communications Commission have various telemarketing rules that they enforce. And here are the general rules surrounding telemarketing. You're not permitted to call or send solicitation text messages to telephone numbers listed on the federal do not call list. I'm gonna put a pin in that before we start getting a bunch of questions, that those are to residential lines. You're not permitted to make calls or text, solicitation calls or text to telephone numbers listed on the federal DNC list. But that DNC list is supposed to be telephone numbers that are residential lines, which include cell phones, but question remains of whether or not it's a business line or a consumer line. We'll talk about that, a lot of cases there. The rules require companies to maintain a company-specific do not call list of people who don't want to receive calls or texts from that company, and that you have procedures to allow people to opt out of receiving those calls and texts, to revoke their consent as well. That's a hot area that the FCC continues to issue rules about, and that we're continuing to see a lot of litigation surrounding this. Laws requiring that certain disclosures be made at the outset of a call, identifying the caller and the purpose of the call. We see that language down there about caller ID requirements. In addition to disclosing who you are at the outset of a telephone call, some states like Florida have specific language saying that if you're going to initiate an outbound call, making sure that there's a caller ID, that you're not spoofing that call is capable of receiving inbound calls. We'll talk about that in a bit. Disclosure, scripting, and consent requirements if you're selling things, getting people's consent to actually be charged. Time of day restrictions about when telemarketing calls and texts may be made or sent. The federal TCPA says that you're only permitted to make telephone solicitations between the hours of 8 a.m. to 9 p.m. And that's in the recipient's time zone. So if I'm sitting in New York, that means 8 a.m. to 9 p.m. If I'm sitting in California, that's Pacific time. So being careful of the trip ups there. Very big restrictions on the use of automated telephone dialing systems and pre-recorded voice messages, including AI messages. And there's very specific consent requirements there and record keeping requirements if you are engaged in these outbound activities. Now, the question for us today is whether or not business-to-business calls and texts are exempt, and if so, under what circumstances. And until March of 2024, the telemarketing sales rule had a categorical exemption for business-to-business calls and texts. But In March of 2024, there was an amendment to the telemarketing sales rule that now prohibits deceptive and abusive practices, like the abusive practices that Ellen was talking about, in business-to-business communications, calls, and text messages. And it also imposes extensive record-keeping requirements. The Telephone Consumer Protection Act, which provides for a private right of action, up to $1,500 per violation, where we've seen cases with millions, multi-millions, and billions of dollars in potential penalties. Those rules do not include a categorical across-the-board exemption for B2B calls. So some of the rules apply to those calls and text messages and some don't. We talked about restrictions on the use of auto dialers and pre-recorded messages. Those apply to all calls and texts made to wireless numbers. Doesn't matter if they're B2B, doesn't matter if it's a consumer. So keep that in mind. It doesn't matter what you're selling, that's going to apply. If you're using an auto dialer, pre-recorded voice, you have to get a very heightened level of consent. You've got to provide specific disclosures. You can't condition a purchase on consent. And that might mean in your standard contract, you better take a look at it to make sure that if you're going to be selling those, that you've got that specific language and you've got that opt-in, and that's not required for people to sign that contract. The FCC's calling out restrictions don't apply to B2B telemarketing calls, but you might, there are some state laws that we'll talk about, and then suppression requirements don't apply to telemarketing. So scrubbing against the national DNC registry, like I mentioned earlier, technically don't apply to business calls, but let's put a pin in that. We'll talk about the cases as well. But caller identification rules saying that you can't spoof your telephone number, those do apply to telemarketing calls made to businesses. Do you want to talk about the telemarketing sales rule?
I do, and so as she mentioned, there are very specific parts of the telemarketing sales rule that will now apply to B2B calls. A quick note on this, why this is so critical to stay on top of, is because under the TSR, the FTC can get civil penalties for violations. So they like phone-based conduct that they can go after because they can get money from it. They have difficulty due to various sort of legal meanderings of the law getting money for past violations of just a UDAP type thing. But if it's something where they have a very specific rule with civil penalties, they will go there. So you have to pay attention to what is in the TSR and what applies to businesses. We've listed out, these are some of those things that fall under those deceptive and abusive categories that now very clearly apply to B2B. So can't misrepresent the total cost to purchase any goods or services. You can imagine how much this could potentially encompass. This could potentially encompass add-on fees, maybe even an early termination fee, something like that. Just know that our regulators and our law, when they become law enforcers, they go very broad on how they interpret things. Any sort of material aspect of the performance or characteristics of what you're selling to another business. If you're selling, I don't know, a tax software to help do taxes, and you tell the businesses that, you know, using your tax services can help them save, you know, this much money, or, you know, find this much money off in their taxes, and you don't, and it's sold over the phone, that could come into here. So refund cancellation policies, exchange policies, those are always sort of easy targets because they generate a lot of complaints whenever the customer sort of doesn't get their money back or feels like they've gotten a bad deal. So those can now be tracked, and if it's again over the phone, it's here. And then I'm gonna skip to the last one, but any material aspect of a negative option feature, I think negative options and automatic renewals are coming up very soon in our discussion, but for not to skip ahead too much, but we were all watching sort of the click to cancel rule for a long time, which would have applied to B2B. It was, you know, enacted and then vacated, but the FTC does not need click to cancel to enforce an automatic renewal type issue over the phone. It already has language in there, and you can see it here now applying to B2B. So there are negative option is, you know, the big term for automatic renewal. So you know, disclosure requirements need to be made. over the phone, and those are in the TSR, so.
That's right, and we had a question, I think you preempted it, about the FTC's rule on negative options, that click to cancel rule. Somebody asked, I thought that was dead, I thought that was squashed. That rule, the Eighth Circuit did strike down that rule. However, as Ellen said, there are still very specific requirements for automatic renewal, negative option sales over the telephone. There's a law called the Restore Online Shoppers Confidence Act, we'll talk about that deals with auto renewal provisions made online. There's been a lot of activity where the FTC has challenged that and the states. And there are state auto renewal laws as well that apply to those provisions. So just because that rule died, I think a lot of people were sort of cheering when that rule died. I mean, it's bad that it died, but the FTC doesn't really care. They're going to enforce, I think, most of the things they wanted in that rule anyway. It's just that now they don't have a rule that explicitly says that.
Okay, and then our last thing I think on the TSR is to I think we did flip slide. Oh no, we're here, never mind. This concept of the substantial assistance doctrine, so just a reminder, we have talked about this many times over, but there is a concept that has been in the TSR for forever. It wasn't new, it's not new in the new B2B stuff, that prohibits anybody from providing substantial assistance or support to somebody else that is violating the TSR. And all of the most meaningful parts of the TSR prohibiting, like deceptive telemarketing practices or credit card laundering, things like that you can see here. So it is this provision, but the FTC likes to go in the business to business world and go after the businesses that are business clients, and they are providing to those business clients, and the clients are selling over the phone in some way that is not okay under the TSR. This is a way to rope in sort of the vendors to this community of people. So payment processors are like, I think, target number one of these things. Lead generators have been involved, list brokers, robocall services that are providing that feature, telemarketing call centers. We know a case from many, many years ago where a call center got merely reading the script that somebody else wrote, and the FTC's theory was what you were reading was so blatantly false on its face, you should have known that this was a violation of the TSR. So fulfillment houses, mailing services, just about anything. More recently, we've done other webinars and articles on this merchant of record concept, but if others like tech support scammers have been in the crossroads there under these merchant of record models, so that's sort of getting into the substantial assistance. And again, with the civil penalties, it's a very attractive thing. So, okay, wait, we have to give a CLE code.
Yes, the CLE code is sales 2025, sales, like when you're selling sales, 2025. And one thing that I wanted to say too is that when you're looking at this list, the substantial assistance doctrine, it's really the FTC's way of targeting companies at what they consider the choke point. Choke off any type of illegal or unlawful conduct at the way that they can get that and get the most companies. The problem with this though is that when you're thinking about this, you offer services to a lot of different companies. What are you supposed to do? You're just reading a script, you're just offering a service. What this really tells us is that you have to vet your customers somewhat. There's a know your customer type process. So it's not just about when you're selling to companies to try to get that business, but as you're providing that service for those companies, doing a little bit of due diligence on the customers that you're onboarding.
Okay, and then if that wasn't enough, there's a whole slew of state stuff.
Mm-hmm. And we talked about that. The registration requirements we wanted to talk about specifically are Texas and Florida. Those laws, so Texas in particular does not provide an exemption for B2B calls. What that means is that if you don't register as a telemarketer and you don't fall into one of the other exemptions, you're required to register with the Texas Secretary of State. And if you don't, there is a private right of action, and we anticipate that in a couple months, we're gonna start seeing lawsuits that are alleging violations and seeking $5,000 per violation. We guess that the plaintiff's attorneys are gonna say every call, every text made to a Texas resident without being registered is a violation. So think about 5,000 multiplied times your texts or calls. That's a big one. We talked about consent. We talked about do not call requirements. Calling hour restrictions is a big one as well. If you're calling somebody on the West Coast, just because you're calling within the permitted hours on the East Coast, you got to be careful because you might have customers nationwide. And if you have an oopsie moment, that's another type of lawsuit that we're seeing a lot of. As well as caller ID requirements. The one thing with caller ID requirements that I'll say here is that if you're sending text messages using a short code, laws like in Florida say that the outbound, the originating telephone number has to be capable of receiving return calls. Short codes by their very nature are unable to receive return calls. So be really careful if you're using short codes. There's ways to reduce risk, but that is a really hot area of litigation that we're seeing a lot of challenges, a lot of lawsuits, and a lot of companies are saying, what the heck, everybody use short codes, but unfortunately, plaintiffs' attorneys now have that in their crosshairs.
Lawsuits?
Yeah, here we go. Some example cases. So we talked a little bit ago about the National Do Not Call Registry. The National Do Not Call Registry and the laws under the TCPA say that you're not permitted to make a telephone solicitation to a telephone number that's listed on the National DNC Registry. And that's a huge list of telephone numbers. But those are only supposed to be residential numbers. People are only supposed to register what's known as their residential number. And the way that's been interpreted by courts is a number that you use for personal. Even if it's a cell phone, courts have said, for the most part, cell phones can be residential. Some courts have said other, but that's a prevailing view, is that if somebody's using a telephone for their personal purposes, that can be listed on the DNC registry. And if you're a company that calls or texts that company or that telephone number with a marketing purpose without, for example, consent or an existing business relationship, then you have a problem because you're not permitted to do that. The question then becomes, what happens if I'm calling business telephone numbers? And there have been a couple of cases on this where, let's say there's multi-use. I have a cell phone, I'm a real estate agent. I use my cell phone both for my friends when Ellen calls me, but also when my clients call me about a listing. So here's an example of one where the plaintiff registered its telephone number as a business phone number with a state insurance website, but they said that they also used it as a personal number. And the problem was that the company that was selling products to insurance brokers was getting those telephone numbers off of registration lists that were publicly available for people who use these business numbers. But the plaintiff said, no, I use it for both. The court said, look, I'm not going to decide this right now on a motion to dismiss. I'm going to let y'all litigate it out for a couple of years. And you as a defendant are to spend you will need to spend the money through discovery and other issues to figure out whether or not this is really a business number or a personal number. In another case, there had been multiple lawsuits filed against another company where the plaintiff in the past had used that phone number for business purposes. The judge said, that's a business telephone line. You can't bring a do not call violation against the defendant over this. But then it was a solicited cell phone. The plaintiff stopped using it for business purposes and started using it for personal phone number as personal number. And so after that first case where the plaintiff lost, he brought a lawsuit again, and the court said, no, now it's his residential number. He stopped using it for business purposes. So really, really sticky. It's really, I don't know how you as a company are supposed to figure out, like, hey, Ellen, is that, I mean, so
I don't know. People have a lot of time on their hands.
Yeah, and these are very lucrative lawsuits. That's the problem. That's why we're talking about it today, because it can cost you a lot, whether it's in the ultimate judgment, whether it's settlement, whether it's just a headache of dealing with the lawsuit regulation. And junk fax lawsuits do remain prevalent. So if you are sending text or faxes, talk to us. We're not going to talk about it here a lot, but if you have questions, that is an area of a lot of lawsuits as well. And then auto renewal laws. We previewed this. If you're selling something on an automatic renewal basis, typically the state laws had only applied for consumers. And the reason why we're talking about this is that those laws provide incredibly strict requirements. Things like if you were going to be auto renewing for 1 year or more, you've got an annual auto renewal that then renews. You have to give a disclosure between 30 and 60 days for some states, or 25 and 45 days in Colorado, or 30 to 45 in other states. So really technical requirements that in the past we told companies, look, you can comply with the spirit of the law because you don't want to be deceptive. You don't want to get in trouble under the UDAP statutes that we were talking about, the general statutes. don't worry about the specifics as much. Just don't, get the generals right. But now, unfortunately, we are gonna have to start looking at the specifics. One of the laws is Virginia that includes small businesses as a potential plaintiff under these. So now you have to comply with Virginia law, even if you're selling to companies and not selling to end consumers. Also, cancellation requirements is a big one, how you permit people to cancel, allowing people to cancel online if they enrolled online. The New York Fair Act that we were talking about too is now going to expand the potential scope to business consumers, business customers. And then some of the longstanding auto renewal laws that apply to things like maintenance and service and repair contracts have always applied in business to business transactions. We haven't seen a lot of lawsuits under those, to be clear, but I suspect that we might. So keeping in mind, if you have an annual contract that renews for another year, even if you're selling to businesses, take a look at that. Make sure that you're complying with some of those stricter notice requirements, because that's going to be another gotcha that I imagine plaintiffs' attorneys are going to start going after. Oh, you want to talk about ROSCA?
ROSCA. Okay, so what you see in front of you is literally the ROSCA law. So ROSCA is alive and well. ROSCA is an act of Congress, and so it was, the FTC really has nothing to do with this other than that they enforce it. The FTC doesn't have rulemaking authority to write rules to expand on these 3 prongs of ROSCA, but it has interpreted them in its way and has been very aggressive in ROSCA enforcement. So ROSCA, to me, is a true consumer protection law. It was enacted by Congress years ago after people would go online or like their deliver online, and then after that have a separate offer given to them by a third-party seller, and by the click of a button, maybe they thought they were confirming their order, they are now enrolled like a book of the month club or traveling services. They have this other part of ROSCA which requires disclosure, consent, and a simple cancellation to get out of any offer with a negative option, whether it's on the front end or on the back end, or whether it's an initial offer or a cross-sell offer or an upsell offer. So ROSCA is really simple, but the key thing here is that it's any transaction affected on the internet through a negative option feature. And if you got that, then you've got to have the clear and conspicuous disclosures of the material terms. You need to obtain express informed consent, says consumer there. And you have to provide a simple mechanism for the consumer to stop the recurring charges. The FTC though has been, let's go next slide, they have been aggressive here in a way that I really dispute whether this is what Congress intended. But they have had at least one case where they went after a payment processor actually. And the FTC's theory there was that the agreement that the payment processor had with its merchants had an automatic renewal provision in it, an evergreen provision. And that makes sense in a lot of business transactions, including in payment processing services. You don't want services to just stop on December 1st because the contract end date is on that day. People will lose their ability to process payments and generate revenue and do all those things. So very naturally, they would have sort of these automatic renewal provisions, as a lot of business agreements do. But because the merchants were signing up for their services over the internet, even like I think even like a DocuSign type app where they would get a link to click on and electronically sign an application. The FTC took the position in a complaint that was not litigated, so no court has agreed that I know of with the FTC on this theory, but all it takes is for them to allege it, and then you kind of have to question it. But the FTC said that that was a transaction conducted over the internet, and therefore it was subject, because it had the automatic renewal provision in it, it was subject to ROSCA, and the FTC used that theory to, I think, extract money in the case, when the case was really about other issues the FTC raised, and sales. And by the way, FTC complaints, when you read them, like, they're always like very one-sided. They're often, to us, seemingly exaggerated or cherry-picked. So when you do read FTC complaints, they sound very scary and the context sounds awful. There's always sort of another side of these things.
Oh, yeah,
But
there's two sides or three sides of the story. There's the truth and then the two sides.
but that is how Roscoe was sort of brought into this here. So so that's a very real concern. But should we do a little bit more on negative options or automatic renewals? Let's see, go to the next slide. What do we have here? So this is, I think, just a review. This actually came out, it's probably a good time now to talk about click to cancel a little bit real briefly, just for a minute. We're running a little short on time, but click to cancel vacated, as we said, but it very clearly would have applied to business transactions. In fact, the FTC's commentary on it included a lot of the payment processing type arrangements and this things like that. But so the FTC did give some examples, and they were helpful in saying, like, a software installment sales contract where you might sign up for, you might agree to get services for a year, but it ends, and you might agree that your payment terms are to pay in installments every month. They wouldn't find that to be sort of an automatic negative option type of thing. But if that contract auto-renewed at the end of the year instead of terminating, then it's that automatic renewal portion of it that would come under it. So anyway, that's sort of how the FTC was thinking about it here. Maybe we should go to the next slide.
It's a big one. I'm excited about this one.
Yeah, so our next slide, we were gonna talk a little bit of, we get a lot of questions like, why, and then the automatic renewal issue tees this up, because an agreement, a business transaction that has an automatic renewal clause is so often negotiated across the table at arm's length. Sometimes it's not, sometimes it's boilerplate stuff, and sometimes it isn't. And so we get a lot of questions, well, how come if I have a contract with my business customer, why do I have like UDEP problems? So there's a debate in this. It kind of comes out in the commentary and the click to cancel rule a little bit, but I don't.
That's right. I mean, because there's a lot of considerations when you have a contract. When we're online, we're buying something, I'm buying a shirt online, I'm typically not going to go to the terms and conditions and click on that and read through that. But if I'm a business that is using something that's a little bit more expensive, I'm using it for my business and this is going to impact my bottom line, it's going to impact my cost, shouldn't I be expected to read that contract, maybe even hire a lawyer? I mean, that's what we do. We read those contracts a lot of times with the service providers. Even if it's a lower cost contract or lower value contract, reading that. And then the question becomes too is, do they have the ability to negotiate it? When Ellen's talking about unfairness, do they have the ability to avoid whatever the harm is that the regulators are gonna say? So really there is this question about the sophistication of the customer that's being entered into this contract, and this idea that, let's say there's an auto renewal provision and you had to give 30 days, they forgot to give notice and now they're going to renew for a year. Is that something that the FTC should intervene in? Should that be a defense if you've sold a service and they forgot to cancel it and you had put that on the books, right, as another service that's going to be provided to another customer for the next year? Should they be able to go and sue you or prevent payment and use that as a defense for preventing payment? I think these are all sort of sticky questions. But if you are selling to businesses, you should look at your contracts. You should look at them from that lens. Like, what is the FTC gonna say if they wanna challenge it, or the CFPB or state AG? Or what is the plaintiff gonna use? If I'm using this as a form contract with my customers and they decide that they're gonna charge back a payment, or they're just gonna not pay if they're paying through another method, they're just gonna withhold payment, and I have to go and try to enforce the contract and get money from them, are they gonna then counterclaim or argue that it's unconscionable because I've got these unfair provisions? So I would encourage everybody on this call to look at your contracts from that lens with these things that we're talking about, to see if you're at that risk. Because putting everything else aside, even if the FTC is not going to come after you, this is something that companies are starting to use to avoid payment in their services contract.
In the private litigation, we will often see a breach of contract claim lined up right next to a claim under the state's UDAP law, where the state has a private right of action. So they're pulling them
They're
together.
putting it all together, because why not, right? All you need is one court to say yes for it. Let's talk about a couple of examples of cases. In the sweepstakes and promotions cases, we've seen various lawsuits over the years where you had companies that are hiring service providers, for example, to underwrite promotions or contests, and then they want to cancel the service. In the first case there, you had an example of a plaintiff who decided to cancel the service and to co-sponsor with a different promotion. They backed out essentially. And the plaintiff lost in the lower court, but then the Fifth Circuit reversed and rendered judgment of $4.4 million in favor of the service provider. Then you have another sponsor versus a promotion administration. This was the Monopoly game where a restaurant sued an agency after the promotion agency's director actually diverted the game pieces that were going to win the big prizes. And so you can imagine that lawsuit was pretty salacious there. And then you had companies that just challenged competitors. And this was in the sweepstakes and promotions context. This happens all the time in every context where you have anti-competitive behavior that's then being challenged by your competitors. Endorsements and testimonials, we think about this a lot in the context of consumer-facing advertising, but it happens as well in the business to business. So we have one company that sued a reseller and it alleged that there was false association, endorsement, false advertising after the reseller of the fashion would use hashtags online and it used their ads and reposted their ads and images of their models and made references to the founder, this really famous designer, implying that there was a sponsorship. So there was a lawsuit there. We've seen review websites that sue other companies over advertising that essentially promise to provide better services by suppressing or filtering negative reviews, and also use the other company's logos. These law firms, Morgan & Morgan, that had used endorsements and testimonials of purported clients were sued by a competing law firm that said those dramatizations, those client testimonials are not actual clients. So be careful there as well. We had another company, you had, sometimes you have these fake articles or these listings, top 10 supplements. A supplement maker sued one of these companies and said, hey, your listings are not really independent. You're being paid by other companies to list my competitors as number 1 and I'm listed as number 9. And there was a whole lot of case law surrounding this about whether or not this was commercial speech or whether the First Amendment protected it. And the Ninth Circuit in that case said if you're a review website, you can be that can be commercial speech and you can be sued over that. So be careful if you're doing advertising in that way or using it. Let's talk about AI. We've had a number of questions on that here. So there have been multiple business-to-business disputes concerning artificial intelligence, and these are just a couple of the ways that things can go sideways. Companies that use AI that are generating various images or content, there's been a ton of IP disputes that say that, look, you're taking other information, you're taking my books, my music, and you're creating content from that, you're making it publicly available. Otherwise, I would have been getting licensing fees. I would have been making money off of that. That's the whole reason I engaged in this creative endeavor. And now you have a lot of companies that are getting sued for making that stuff available. But not only the companies that are making the content available, but also companies that are using that content. So if you're using an AI service provider, being mindful that there might be IP concerns there as well. So if you're selling something that uses AI or promotes efficiency through your use of AI, or if you're buying it and then selling that to other businesses, other consumers, as we think of those, being mindful that IP is a very real consideration. And not only in just the general sense, but also you might have contractual disputes coming out of that. Discrimination. We've seen this in the employment context and other contexts where advertisements are being made or AI generation is being made that then, let's say in the real estate context, only target specific individuals and in specific categories that could be viewed as discriminatory. Antitrust is another area, the use of having specific information that's only available to some and not others, or that you're taking that to have an anti-competitive advantage. Privacy lawsuits and the use of personal data. That's a really big one. If you're using AI and that AI is somehow scraping data that could be viewed as personally identifiable information that didn't really belong to you or you weren't permitted to have, that's going to be something. And all of these are issues too that you want to be looking at in a contract if you're selling anything that uses AI technology or you're using it yourself. Data broker issues. Are AI services data brokers under state laws that need to register? That's something that could come up because there are new state laws and existing state laws that say if you are a data broker, if you deal within certain types of data and you have a certain amount of data, you have to register. And then a really fun issue is data scraping. So in order to populate the language to these large learning models, you have to get the data from somewhere. And a lot of times that data is taken from publicly available websites. And then the question becomes, if those websites have terms and conditions that say you're not permitted to scrape these websites' information in content for commercial purposes, and then you do that, and that's what the AI is taking from that content, are you violating those terms and conditions? And is that a violation of contract? And we're seeing cases come out about that. There's questions about whether it's fair use, whether it's public content, versus whether it is proprietary and something that by contract can be restricted. And then our last topic here is the recent developments in B2B contracts and disputes. Early termination fees, we talked about a lot. Again, that is a huge area of dispute. And if you do have early termination fees in your contract, look at those. Those have to be really carefully drafted to avoid being considered impermissible liquidated damages provisions. This idea really comes down to the following. An ETF cannot be viewed as a penalty. It has to bear a reasonable relationship to the damages that you're going to suffer by that early termination. So when you're imposing that amount and the way you hold it out to your customers, whether it's in what I'll call the fine print or when you have your sales reps talking about it, making sure that you can articulate that relationship to the damages. The other way it could be enforceable if there is a difficulty in calculating actual damages, but hey, this is a close approximation. And the reasonableness of that ETF at the time of contract formation. Are people really believing that they're going to get caught into or locked into a contract that is going to require them to pay an ETF? And the last thing is that if you do have an arbitration provision in your contract and you're the one who's selling to your business customers, there's a code of civil procedure in California that was litigated last month. It requires that the party drafting an arbitration agreement to pay the arbitration fees and costs within 30 days of receiving the invoice. This is a huge slip up. Companies will move to compel arbitration. Yes, it was compelled. And then somebody files and then they get the invoice and they forget to pay. Maybe it's because the case is ongoing. And then what happens under that law, and courts are saying that now you've waived your right to arbitrate. Too bad, you're back in court, whether that's a one-on-one or that's a class action. So just be really careful for that. Another reason why you should look at your contracts, but also look when you're doing disputes, be very mindful because there's a lot of slip-ups. So thank you all.
Yeah, thank you for joining us.
We got through all of it. Again, the CLE is Sales 2025. If you have any questions, please feel free to contact us. You'll get the slides. Have a good day, everyone.